All right, this is case D446900, Feindell versus Feindell. Counsel appearances for the record.
Good afternoon, Shelley Lubritz, 5410, on behalf of Ken Feindell, who's present.
Okay.
Good afternoon, Judge Leslie Cohen, bar number 6605, with the defendant, Amanda Feindell, who's also present.
All right.
Do you take offense if I remain seated during questioning, etc.?
In fact, I invite it.
Thank you, I appreciate it.
Let everybody remain relaxed. All right, when we had the status check / calendar call on June 19th, 2012, I believe the only issues remaining are child support, if any, and attorney's fees. Would that be accurate?
Yes, Judge.
I have lots of exhibits. All this pertains to child support?
Yes, Judge. Credibility, attorney's fees, and child support. It's not going towards child custody or any other issues.
All right. I mean, I remember the discussion somewhat the last time. Let me be very candid. This is something that's likely going to get generated, take it under advisement, and enter something probably within the next week or two, especially if I have to look at billings for attorney's fees, requests for attorney's fees, et cetera, et cetera. Which there was some discussion the last time we were here on the 19th, as I'm recalling from my memory, that you said that I had assured you were going to get attorney's fees and then you were going to get me citations to those.
Can I have those citations?
Okay. Is it an exhibit? Because it's something that I will review.
Right. When we were here last, I asked if you preferred me to play snippets, and you said if you'll just give me the video record, and I certainly have that available, and we'll supply it orally. If you would like your marshal to make a copy, this is just my notes, and I brought just one page.
Either way.
I have no problem giving it to everybody.
Either way.
Thank you.
And again, I will go back and I'll literally review the video. Yet another reason why I'll end up taking this under advisement. But I said unambiguously, you're going to get your attorney's fees, because typically
as soon as Marshall gives it back to me, I will read.
Typically, I threaten a lot that prevailing party would get attorney's fees, things of that nature. But I will see. I just want to stipulate, Ms. Cohn.
I don't think we'll get that stipulation.
I don't think so either.
It's warming up. May I read it to the court, and then I can give you a copy so we can proceed?
Everybody have it first.
We're good.
And, Your Honor, for the record, I ordered the video after the last hearing. I still don't have it back, so I haven't seen it. I wanted to
It's not
review
from the
it.
last
Well, it
year.
wasn't from the last hearing. The last hearing is...
No,
Thank you.
after the last hearing, I ordered that video and have not received it back
Okay.
yet.
Actually, since it's an unsealed file, you can simply download it, which is what we did. What I would recommend to the court is at video record 140325 to 140337, Mr. Winesett stated, "That's all we're asking for is to verify his income, Your Honor. So otherwise, I think once we verify it, we can, in good faith, finalize the case." Mr. Winesett went on to ask the court to ask the trial date be set in order to keep the case moving, to which the court responded at video record 140353 to 140404. Here's the thing. Once I set a trial date, somebody's paying attorney's fees. And if you get what they're saying, then you're probably paying their attorney's fees from that day forward. A status check date, probably not, but a trial date, yes. At video record 14-4-26 to 14-04-36, Mr. Winesett stated, "If you just have him disclose all of the checks that he's receiving, the identity of the company, if we feel that is not enough, then we can subpoena his company for his paychecks." Undersigned counsel stepped in and stated at video record 14-04-36 to 14-04-46, "The last time we were here, they said all they wanted was a paycheck stub, and I wanted to redact, and you said no. We gave them an unredacted," to which the court responded at video record 14-04-36 to 14-04-52. "It's all going to come down to what he's filing as far as taxes anyway. I'm not going to give carte blanche. That's as far as I got." If you watch the next minute or so after that, there's other things that the court stated and indicated that are relevant. But you told them flat out, if I have to set a trial date, I'm awarding fees, and based upon what they're saying, get it that you're likely going to pay theirs. Now, I'm not just asking for fees under 18.010 when we prevail. I'm also asking for attorney's fees under Sargent, and we've made that request back in June of 2011 when we made our first child support request, and you indicated those items would be deferred till trial. And I know it's difficult, Judge, and my client doesn't take pride in asking this court as a man to award him child support and attorney's fees, but the rules and the laws and the courts are gender blind, and so there should be no difference between a man asking for it than a woman. Under Sargent versus Sargent, my client is entitled to fees. We've not been able to meet our adversary on relatively equal footing. I've been paid $4,100, a lot of which have gone towards costs. By my last count, per their FDF, their pretrial memo and responses to requests for reduction of documents, over $17,000 has been paid by Ms. Feindell to her current counsel, who received almost $14,000 as of the date of the PTM, and her prior counsel, who received $35,000. Now, she does assert that some of it was loaned to her from the company, but there's been no credible evidence with that information. And so we're looking at $4,100 of community funds versus almost $18,000 of community funds, and it just simply, we've not been able to do all the things we want to do because of a lack of funds, whereas they have had funds consistently throughout these proceedings. With regard to child support, you will hear a lot of information, you will hear closing arguments, you will hear the law, and you will understand our position as far as when someone is willfully underemployed versus when they're not, and you'll also hear from argument and from testimony about when it's appropriate to impute or not impute an income. So that is as far as I'm going to go. Unless you ask me a question directly, that can substitute as my opening argument. I'm ready to proceed, and I don't need to state anything further to the court.
I will let you know that what's implied here is prevailing party, so that assumes you're going to prevail today.
Absolutely, but it's not just that, Judge. We also asked under Sargent versus Sargent.
Well, I don't know if you've ever heard my lecture on Sargent. Sargent, I think, is very fact-specific. Sargent was over a 30-year marriage. Even though Sargent was a 1972 case, Sargent has never been cited for that proposition again. When they made that statement, we were talking, and if you want me to pull up my...
I don't have to.
What's that? And we'll start with this is...
I argued it in virtually every one of these...
This is not even a year-and-a-half marriage, right, where they were together. They were married in July of 2009.
I'm sorry?
I was thinking alimony.
Yeah, I think you're thinking alimony. We're talking about... No,
I'm talking about Sargent.
No, what I'm telling you is what the case law tells us, what the NRS tells us. You will make your decision and your determination however you choose to make it.
Right, it's completely discretionary.
Exactly, and so I don't want to take, with all due respect, usually the clocks are back there, I don't want to take up time with my interpretation versus yours at this point. You'll have your findings, they'll be written, I'm sure they'll be adequate as far as giving your basis and belief for everything. We also have requested fees because of the vexatious and unnecessary litigation that's transpired, all of which will be attested to and testified to by my client, as well as hopefully, if she's truthful, by Ms. Feindell. So there's more than one theory under which we are seeking fees. And the court did not indicate that it was only pursuant to 18.010
I'm not
as
limited to
prevailing
that.
party in the at the hearing in question.
If that's our opening, do you have any?
I have an opening.
All right.
Yes, Your Honor. Your Honor, as you know, plaintiff Tim Feindell, defendant Mandy Feindell, married April 25th, 2009. They're the parents of one minor child, Ivy, born October 12, 2010. Child support and attorney's fees, that's why we're here. The evidence is going to show that Mandy is an office manager for her family business. She grosses $47.67 per month. Tim is a self-employed software engineer who claims to have $19.50 in gross monthly receipts, and that's according to his last FDF, with an average gross monthly income of $16.74. So that's after he takes out for business expenses, including travel and food. While Mandy's provided pay stubs to verify her income, along the way, Tim's provided one pay stub. We know from documents subpoenaed from the company that he does work for that he earns $25 per hour, and I don't think he disputes that. So that comes up to him working 18 hours a week. There's no reason for Tim to be awarded child support in this matter based on his working 18 hours a week. It's basic. In Nevada, you have to support your children. You've got a duty to support your children. Therefore, we're requesting that the court consider Tim to be underemployed pursuant to 125B0808.
The only objection is this is akin to argument, not opening statements, which are to tell the court what you're going to hear, not to argue.
And that's what we do. We do. All right.
Just placing it on the record, Judge.
Go ahead.
Your Honor, so I do want to address that Nevada doesn't have a lot of case law regarding this issue. There's Rosenbaum, which allows a judge to exercise discretion in fixing child support and alimony to consider what the litigant could in good faith earn. There's Minier, which holds that once evidence of underemployment preponderates, a presumption will arise that the underemployment is for the purpose of avoiding support. And once that presumption arises, the burden shifts to provide willful underemployment for other reasons other than the avoidance of support obligation. And that shifts to the supporting parent. And I think maybe that there isn't a lot of case law because it's common sense. You don't have to work full time, but you don't get to make your ex support you.
My objection that she's
It's Lubricants. We don't object in openings in here. We don't.
Opening statement, Judge.
It's argument.
It's not argument. It's opening statements which prohibit argument. Opening statements are to tell you what you're going to hear, not to give you case law and citation. That's for closing argument. And I object to her making argument to you before there's been any testimony, before it's proper.
Do you want me to address that, or may I continue?
You probably should tell me what you're going to show me today.
Your Honor, so what I'm going to show you is, as the court already stated, Tim needs a full-time job. So here's what we're going to argue and suggest to the court, and what the evidence will show that the court should do here. At a minimum, the court should consider Tim underemployed and impute to him an income of $25 per hour for a 40-hour work week. If the court does that, the difference in the parties' incomes is de minimis, and there should be no award of child support. However, previously this court noted its authority to use Nevada average wage to calculate child support in this matter. We're going to request that if you're inclined to use the Nevada average wage, you go into the statewide 2012 occupational wages estimates to determine child support. As a software engineer, that would mean that Tim's capable of earning
objection.
$37.36.
What she says she's gonna.
But how is she going to prove Nevada? Unless they have an expert here to testify what a software developer makes and compare that to Nevada average wage, what she's doing is testifying and/or arguing. Because I looked at their witness list and no such witness appears.
You can take judicial notice of this information from the state. So that's what we're going to ask that you do. That would also, you can consider Tim a web developer. That would be an earning of $35.90 per
Judge,
hour.
I have to object. There is no basis upon which you can take judicial notice of what a software developer, software engineer makes.
Lubricants, at this point, she's indicating what she's going to try to object when she tries to do it at trial.
But how can she do that when there's not been a bad
I don't
faith?
know.
There's not a witness that's been
Let her
listed.
finish her opening.
If you just use the Nevada average wage, we're going to see that Tim still gets a break for not working full time. And the numbers are going to show that he's capable of earning more than the Nevada average wage, and he should be paying support based on that. Also, it hasn't really been addressed specifically, but currently Mandy has health insurance for Ivy and the rest of the family. We provided Tim with proof of the cost of the insurance, so we just request that ultimately the decree reflect that Mandy can continue to have the health insurance as long as it's available to her for a reasonable cost through her employment, and that Tim will pay half of the cost, including increases when she provides proof of that. As for attorney's fees, we're asking that you provide us attorney's fees for having to come to court on this. You're going to see that under NRS 18010 and EDCR 7.60B, Mandy's entitled to these attorney's fees. These statutes allow attorney's fees when basically one party is wasting the court's time. And
I renew my objection. It's argument purely at this point and/or testimony, Judge.
Did you not submit the 3 different bases as to why you were asking for fees?
Yeah.
Okay, so that's all
Judge,
she's
that was
doing.
in response to your questions to me about fees. I just used that time in lieu
I'll
of doing
ask
it
her, Ms.
openly.
Cohn, what is your reasoning you asked for fees?
That would be NRS 18010, 18010, and EDCR. These statutes allow fees basically when one party wastes the court's time. I think we're going to hear a lot today about how everything is my fault, and she and I can snipe at each other all we want, but the bottom line is we're here because he's underemployed and trying to get child support and attorney's fees for my client. And I think we're also going to see that my office did what we could to try to get this matter settled. So, Your Honor, we request that you permit us to submit an affidavit of fees and costs, and you award us attorney's fees. Thank you.
All right. Well, and to be very, you guys have resolved almost all of the issues. It was not unproductive, right? Apparently, last time it was indicated in court, you guys have agreed to homes, vehicles, businesses, et cetera, et cetera. So at least it was somewhat productive. Give me 1 second. Where's my perfect not working? All right.
I'm ready to call my first witness whenever you're ready.
You know what? Give me 1 second. I've only had one other case that I've had to do this in, but I'm going to go ahead and do it in this case. Give me 1 second.
You going to give us a stop clock, or are you going to have the marshal stand between us?
Listen, as long as we stay on point, we can at least even go till 5. We have to continue. We will.
I'm sorry, Judge. Marshall was talking to me. I missed that.
We're not timing either side. Here you go, Marshal Bill. I hope that it's a reminder to counsel regarding the rules. The beautiful thing about family court proceedings is everything is videotaped, including demeanor. So I need you to keep all of that in mind. I think I've had trials with both counsel. Clearly I haven't with parties. I keep copious notes about when stuff is said and when they're said. I have a monitor here, so I can see the witnesses, because the way these courtrooms are designed, it's hard to see you guys, okay? So I have nothing up here but your case. I'm not emailing. I'm not doing anything but taking notes. Okay?
I have
All right.
one procedural question, Judge.
Sure.
I've not actually tried a case before you, and each
Okay.
judge I have found, especially in the last week and a half, does it differently. When we have documents that have been filed with the court or already on the record, do you still have those, mark those? I included them in my books, but do you mark those as proposed exhibits and then have us admit them? And if that's the case, can we just stipulate right now or have you state that any document that's been filed with this court already will come in as an exhibit?
Well, I think, first of all, let me get my 16.2 stuff. I think we kind of discussed this. I don't know that there was any written objections filed. Is that correct?
There were none.
All right.
Of which I'm
So the
aware.
presumption is they are coming in.
Your Honor, I received the trial notebooks yesterday. There were some documents in there.
If
that-
they
I got
weren't-
mine yesterday when they delivered theirs as well.
Your Honor,
If
I
they
may
weren't
finish.
disclosed, object to them not being disclosed 30 days out, and they
Right, that's-
probably
I
won't
just
come in.
wanted to preserve that,
Otherwise,
but I'll
at
be
this
doing
point,
that.
the only thing, if they were not disclosed 30 days out, The only basis you'd have left would be relevance and/or prejudice, confusion, waste of time, all that kind of stuff.
Judge, the only thing I would tell you is that out of my exhibits here, 16, 17, 18, 19, I mean, at least 20 plus have already been filed with the court, so that's why I'm just asking to make things easy. Those items that have been filed with the court that bear a file stamp in the upper right-hand
Yeah,
corner.
the court documents, they're coming in.
That's all I asked.
Yeah.
Thank you.
I don't object to that.
Amanda Feindell is my first witness.
Yeah.
Hi, please raise your right hand. You do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you to be seated. Class, can you please speak loudly into the microphone when you ask questions? Thank you.
How do you prefer that I address you?
My name is Mandy.
Okay, Mandy, I just want to make sure you're comfortable with the informality of it. You understand that one of the two reasons that we're here is for the court to award child support, correct? Or make a
Correct.
determination about child support.
Correct.
And you would agree that in order for the court to do that, the court must have a full picture of the party's income and financial resources, correct?
Correct.
Now, do you recall being served with, or having your counsel served with what's called interrogatories? Are you familiar with that term?
Just from when we talked about it.
May I have you raise the volume of your voice,
Yes.
please? Now, the things that I ask you, and you just concern me a little bit, you said when we talked about it, anything I'm asking you today, I don't want to in any way encroach upon the attorney-client privilege. So when I ask you questions, in your response, if you would refrain from saying things that you discussed with your attorney that might be privileged, so that we don't run into that, okay?
Yes.
Great. And again, I'm going to ask you to speak up. You're a bit far away from me. If you could just raise the volume of your voice, that would be very helpful.
Okay.
Great, thank you, I appreciate that. Now, in the interrogatories, you understand that those are written questions that we ask and that you have to answer under oath, correct?
Correct.
And you recall signing a verification stating that all of the responses contained within the interrogatory were true and correct, yes?
Correct.
Have you reviewed the responses to the interrogatories in the last 30 days or so?
No.
Do you have any reason to think that any of the answers have changed as far as those that you gave initially?
Not to the best of my knowledge, no.
Let's talk about Western Sealants. What is that, please?
Western Sealants is a business that my family owns.
And you have an ownership interest in that business, correct?
Yes.
Thank you. And that ownership interest is what percentage?
16.3%.
When did you acquire that ownership interest?
Well, an LLC was filed in 2009, but I have been since told that that LLC is not...
I'm going to object at this point because she says she's since been told it obviously is hearsay unless she was told by my client, so I'm going to ask before she finishes responding. What is the...
Your Honor,
First of all, I also asked a yes or a no, and she's kind of gone off, but
Okay.
I'm going to ask that when you answer my questions that you use information that you have of your own knowledge from your own observations. Don't tell me what other people have told you unless, of course, it's Mr. Feindell, in which case that would be an admissible statement. You understand that?
Your Honor,
Yes?
I'm just going to object that she's being argumentative. Most business owners do not take LLC documents themselves
Judge, she's
down to the clerk's
testifying.
So
you
what
don't
is,
have
listen,
speaking
we're
judge.
just talking about procedure. Let her get into the substance.
Thank you. Now, my question is, when did you acquire that 16.3 interest?
The LLC was formed in July of 2009.
Is that when you understand? Is that when you understand you acquired the 16.3 interest? Is that a yes?
Yes.
And when were you married?
July of 2009.
Okay. And do you know the date that the LLC was filed versus?
I don't know for sure.
One thing, you're anticipating correctly the question that I'm asking, but we have a record here that I want to try to keep clean, so if you'd be kind enough to not step over my words, I will do my level best not to do the same to you, in case this has to be transcribed so we can have a clean record, okay?
Yes.
Great. So what I'm going to ask you now is, do you have an understanding as to when the LLC was filed with the Secretary of State's office?
Yes.
When?
I don't know for sure the exact date.
Okay, but it was in July?
I believe so.
Okay. And do you know, and what was the date of your marriage?
July 25th, 2009.
Now, how did you acquire your interest? Was there a capital contribution by you, or was it given to you as a gift?
There was no capital contribution.
Was it given to you as a gift?
I don't know how to answer that.
Is there anything that would refresh your recollection?
Can I inquire, so what is, are we not down to income?
We are.
Okay.
And I need to know what her interest is, and also for attorney's fees, well, two things. Attorney's fees also, and it has to the overall financial condition of the parties, not just their income, but there are other things that will come into play, Judge, if you will just trust me enough to know that I know what I'm doing and I'm not going to take any unnecessary steps.
Simply asking, Ms. Luberts.
No, I understand that. There are connections, and I will tie them up. I give you my word.
All right.
Thank you. And also, the truthfulness of the parties is also relevant. So that's another reason why I am asking for some indulgence. Do you recall in responses to discovery indicating that the interest in that entity was given to you as a gift?
Repeat that, please.
Sure. Do you recall in a sworn pleading indicating that the 16.3 interest in Western Sealants was a gift?
Your Honor,
I can't.
Judge, she doesn't have the document in front of her. She testified to not having seen the document in well over a month, and she's asking, do you recall testifying to this?
I'm trying to refresh
That
her
wasn't even-
recollection.
Then she
on
can
the
look
title
at it, or
of
is it not up there?
It's not up there.
Why don't we get to the point, though? I mean, can you, if she says she doesn't remember, can you turn her to it?
Sure, Judge, but I really would ask that I not be, my credibility is a cornerstone of my argument for attorney's fees and for child support, and I would ask that I not be impeded in putting on my case the way that I think it's appropriate, unless I'm doing something wrong, in which case, please tell me.
There comes a
But
point where she says she doesn't know, though. If she
said
doesn't
that
recall.
She didn't know how to answer it, and then I was trying to refresh her recollection without having to get up and put documents in front of her because her truthfulness and her credibility is of the utmost, and I'm asking that you please allow me to put on my case without these
Luberts,
interruptions.
go right ahead.
Do you recall signing a document under oath indicating that the 16.3 interest in Western Sealants was gifted to you from your parents?
I don't recall. I
Thank
don't
you.
want to say something that's
No,
untrue.
ma'am, there's no
We
question
not have a
pending.
copy. I don't want the back and forth. Do we not have an extra copy for her? The witness stand?
Which one?
There's not an extra copy for the witness stand?
I'm sorry, I always have a court copy, the clerk's copy, which is what they're supposed to testify from, and I give the court a copy, and I give opposing counsel a copy, and I have a copy myself. I've never been asked to give a witness copy because then they're not testifying from the exhibits.
It's just typically.
I'm sorry?
We usually have.
Sure. That'll save me some trip. Thank you, I appreciate it. I know, it's a good one. Yeah, the office likes the 4-inch binders. May I approach the witness, Your Honor?
Yes.
Thank you. And when I refer to proposed exhibits or exhibits, and I do it by number, the books that I'm going to put in front of you are numbered and they have tabs so that I don't have to remain up here the whole time. If you would please be able to flip through. If I ask you to look at number 18, for example, that's this one that I'm pulling out. I'm going to ask you to look at the very last page of proposed exhibit 18, and I'm going to ask if that is your signature.
Yes.
and it's notarized, and this is your verification to the answers to plaintiff's first set of interrogatories to defendant. Is that correct?
Correct.
If you would take a look at this document, and first of all, Judge, I would ask for its admission.
First of all, they're presumed admitted. Do you have any objection to, should we go through the list? I probably should have done, I usually do that on the forefront. Do you have any objection to her 27 exhibits?
Some of them, yes, Your Honor.
Okay, I'm sorry. All
But
right,
not
then.
this
No?
one. To make things easier,
Sorry.
not this one.
All right, will
Great.
be admitted?
Thank you, ma'am. I'm going to ask that you take a
18's
look
admitted.
at page 5 of that exhibit, and please tell me when you're there.
Yes.
And if you would look at line 24, it says 16.3 of Western Sealants, value unknown and gifted from parents. Do you recall that now?
Yes.
And so, in fact, the 16.3 was gifted to you from your parents, correct?
Yes.
Now, with regard to the value unknown, what have you done, if anything, since signing this document in October of 2011 to ascertain the value of Western Sealants?
I haven't done anything.
Do you believe that, you understand that the court has to have an understanding of your complete financial status, correct?
Correct.
And as an owner of 16.3 of Western Sealants, you recognize it would be important for the court to be able to quantify what that 16.3% is worth in order to assess your financial status, correct?
Correct.
And that's important information for the court to have today, correct?
Correct.
And you've done absolutely nothing to provide the court with a value as to that 16.3%, correct?
I have done nothing.
And despite the fact that you recognize it was important information for the court to have here today, correct? Yes or no?
No.
No, it's not. You don't recognize it was important, or no, you don't think it's important?
I don't think it's important. No.
Okay, now you know just a moment ago you just testified when I asked you that it was something important for the court to have an understanding of today, correct? Do you recall that testimony
I do
moments ago?
recall it.
Thank you.
Yes.
Now, with regard to Western Sealants, I understand that you receive a salary, correct?
I do.
And how much is that salary?
$1,100 a week.
And do you receive any perks as an owner?
Monetarily? No.
Okay, let's ask, then when you say monetarily, what do you perceive as a perk that you receive being an owner of Western Sealants?
I take my daughter to work with me.
Okay.
That's a perk.
Let me ask you this. Who pays for your gas?
Who pays for my gas?
Yes, ma'am.
The company.
Okay.
You're
Now, on your financial disclosure forms, let's take a look at number 7, please, if you will. And Judge, I would move for its admission as it is a document that was filed with the court.
No objection.
And while I'm doing that, I'm going to ask the same for number 8, which is her second financial disclosure form. Great. Now, before we go any further, you indicated that you were the office manager of Western Sealants, yes?
Yes.
What did Western Sealants gross in 2011?
I couldn't tell you that.
I'm sorry?
I couldn't tell you that.
And how about 2010?
I can't tell you that either. I don't have that information.
Okay, and have you ever had that information with regard to 2011?
No.
And do you understand that as a 16.3% owner, that information could be of assistance to the court in determining what your financial status is?
It could be.
Okay, thank you. Now, as office manager, is one of your duties to produce payroll documents
Yes.
and to complete payroll documents?
Yes.
In fact, you're not just, you're a managing member of
Yes.
Western Sealants, yes?
Yes.
Okay. Now, the payroll documents that you produced through the course of discovery, were those generated by you?
No.
Who generated those documents?
Intuit Payroll.
And is Intuit Payroll a service or a computer program?
It's a service.
And who provides the information to Intuit in order to generate payroll information?
I input the information.
And who prepares W-2s? I don't care about the company. Who prepared your W-2 for 2011?
Intuit Payroll.
Ma'am, please allow me to finish my question. Who is it that prepared your W-2 for 2011?
Intuit Payroll.
And who provided the information to Intuit in order to generate that W-2?
I input into Intuit.
I can't hear you. You what?
I input the information into Intuit Payroll.
Okay. And so the answer is that you provide that information to Intuit, correct?
Yes.
And does Intuit do an audit of the information that you provide?
No.
Okay. Now, you had a significant pay increase between 2010 and 2011, is that correct?
No.
That's what that was.
Do you have a book 2 of 2 up there with you? No, I see it up here. Let me grab it real quick. Oh, you left it? Yes, ma'am. Thank you. Thank you. Counsel, I'm going to be referring her to one of your documents. I assume that you won't have any objection. It's going to be Exhibit 19, which is the response to production of documents that you produced. Is there an objection to admission of that document?
There is not.
Okay, thank you. Amanda, are you familiar with what a bait stamp is?
I'm sorry?
Are you familiar with what a bait stamp is?
A bait stamp?
Yeah.
No.
In the lower right-hand corner, if you'll go to, I'll approach this once. In the lower right-hand corner, there's alphanumeric numbers. For example, if we look at number 19 and we flip through, do you see that, for example, I just opened to AF with a bunch of zeros, 016?
Mm-hmm.
When I refer to a bait stamp number, I'm referring to an alphanumeric number that would be in the lower right-hand corner, okay?
Yes.
Great, thank you. Now I'm going to ask you, please, if you would go to bait stamp 144.
I'm there.
Okay.
Yes.
And if you would look, please, at 144 through 146 and tell me if these are the payroll summaries produced by Intuit about which you testified earlier.
Yes, they are.
And I note on top the first page, 144, says Western Sealants payroll summary for Amanda P. Feindell, correct?
Correct.
And it's from 1/1 of 2011 to 12/31 of 2011, correct?
Correct.
And if you look at the second page of this document, which is 145, your gross annual pay was $44,000. Is that correct?
Yes.
Now, if we look at the next page, it says 1/1/2010 to 12/31/2010. Do you see that?
Yes.
And the only page that we have for Western Sealants payroll summary for you is bait stamp 146 that was produced, correct?
I'm sorry, say that again. I was looking at the page.
The next page, 146,
Yes.
is your payroll summary for 1/1/2010 to 12/31/2010, correct?
Correct.
Now, can you please tell me why it starts at September 1st of 2010 and goes only for 3 months?
Because we were not on a payroll system before that.
Okay, and what system were you on?
We were on a 1099 system.
Okay, and what was your 1099 for the first 8 months of 2010?
$1,100 a week.
Okay, and did you produce those documents? No?
No.
So the only thing that we have to understand that would be your testimony here today?
Yes.
Okay. And do you understand that we requested those documents?
Yes.
And you failed to produce them, correct? Yes or no?
Yes.
Okay. And you understand that when documents are requested, especially financial documents for, let's say, I don't know, your income, that would be something that would be important for the court to have and to be able to consider when trying to make a determination as to child support, attorney's fees, and other factors, correct?
Yes.
And notwithstanding that fact, you failed to produce those documents, correct?
The documents are here in this file.
Ma'am, notwithstanding that fact, you failed to produce anything other than 3 months of payroll summary for 2010, correct?
Yes.
Okay. Now, as of between 9/1 of 10 and 12/31 of 10, you earned $23,384.71. Is that correct?
Yes.
Now, and that's for 18 months, right? I'm sorry, 18 weeks, correct? Basically shows us 1 quarter.
Yes.
Okay. And if you understand a quarter is 3 out of 12 months, right?
Yes.
And if you multiply 21,000 times 4, what do you get?
Somewhere around 80,000, but that doesn't.
Okay, thank you. So your testimony is that you receive $1,100 a week,
Yes.
and that's your pay,
That is gross. Yes.
and that despite that testimony, you received gross pay in the amount of $21,083 for just 1 quarter of 2010, based upon this document that you produced, correct?
Correct.
So you did take a significant decrease in pay according to these documents after the filing of or around the time of that you and your husband are having difficulties, correct?
No, I did not take a significant decrease
Okay.
in pay. I was
Can
paid
you
$1,100 a
reconcile,
week.
ma'am, can you reconcile why, according to the documents that you provided for 2010, you were making in excess of $80,000 a year if you're getting $1,100, strike that, if by between 9/1/2010 and 12/31/2010 you had earned gross pay of over $21,000?
No, not the way you're asking it.
Okay. Are you saying that 146 is an inaccurate document?
Say that again?
Is bait stamp AF 146 an inaccurate document? Is it wrong?
No, it's not wrong.
Okay. Thank you. But nevertheless, you agree that if someone is based on a salary and has made $21,000 over the course of 3 months, over the course of 12 months, it would be in excess of $80,000, correct?
The way you're saying it, yes.
Thank you. Now, moving back to Exhibit 7, which is your first financial disclosure form, file 620 of 11.
Yes.
Let's look at, please, page 2. And is this your handwriting?
Yes.
Now, you indicated that your gross monthly income is $4,400 a month, correct?
Correct.
That's an inaccurate statement, is it not?
No.
If you get $1,100 a week, and there's 52 weeks in a year, how much are you going to make?
I'd have to do the math on that. You didn't ask that, though. You asked me if I made $4,400 a month.
Right. And you don't make $4,400 a month because on the same number, if you look at the next exhibit, which is Exhibit 8, page 2 of Exhibit 8, and I'm sure you heard your counsel too state that you actually earn $4,767 a month, correct? Yes or no?
Correct.
Thank you. Which is different than $4,400 a month, right?
Sure is, yes.
And there was no change in your pay between June 20th of 11 and May 24th of 12, correct?
Correct.
Thank you. Now you have a health insurance deduction on page 2 of Exhibit 7 for $380.47. Do you
Yes.
see that?
Correct.
Now do you also see how part of the line is missing?
Say that again. I'm sorry. What?
Do you see where on line 5 of page 2 of Exhibit 7, that part of the line where you wrote $380.49 is missing? You white it out. Do you see that?
Yes.
What was on there originally, please?
I have no idea.
It's your handwriting, is it not?
Yes.
Okay. Now, did you provide any documentation timely to support the $380.49 deduction that you received? And where did you provide that and when?
It's in our family wizard.
Okay. Let me ask you this. When did you provide that information to your lawyer to give to me through discovery?
I provided that to my lawyer last week.
Last week. Okay. And you understand that discovery had closed as of last week, correct? Is that a yes?
Yes.
And so it's fair to state that you've not produced anything upon which I can rely to verify that number, correct?
No.
Now, who is covered for that $380.49?
Me, my daughter Ivy, and Emily.
Okay. And is there a what is the breakdown for just covering you? How much is that?
I'm not sure. I'd have to look at the paperwork again.
And that paper would be the document that you provided your lawyer last week?
Yes, from Anthem Health Insurance.
And are you on a plan so that it doesn't matter how many dependents you have, that as long as that it's basically yourself or yourself plus family?
Correct.
Okay. And you also understand that you have no requirement to provide health insurance for my client's child that is not of this marriage, correct?
Correct.
And in fact, this court has indicated previously on more than one occasion that Emily's off the table as it relates to this case, correct?
Correct.
My client has indicated to you in emails that he didn't want you to continue to cover Ivy because I'm sorry, Emily, because he covers her, correct?
No.
Okay. Now, do you have an objection to Mr. Feindell providing insurance if he can do it for Ivy, if he can do it more cost effectively than what you're paying? Yes or no?
Yes.
Okay. And are you then willing to pay the difference between whatever the expense would be that Mr. Feindell could cover Ivy for versus what you're requiring her to have carried?
No.
Okay. Now,
No, you're not willing to, or no, you're, I'm sorry, I missed.
No, I'm not willing to because not all insurance
that's
is
fine.
created equal.
Ma'am, that's fine. Thank you. You're not willing to do that, so that's fine. It's obviously relief we'll ask of the court, but I wanted to know if it was something that we could just resolve here. Now, let's move to the next page, please, of Exhibit 7. And Judge, I promise I'm only going to do this once, and I'm only going to do it on one exhibit because it's going to take a little bit of time, but I'll run through it as quickly as I can. Tell me when you're on page 3 of that exhibit, please.
I'm there.
Great, thank you. Now,
I'm sorry, which page are we on?
page 3 of Exhibit 7, which is her first financial disclosure form. Now, you see on these pages how there's lines 1 through 24 that run down the left-hand side?
Yes.
When I ask about a line item, I'm referring to those numbers, okay?
Okay.
Great, so let's look at line item number 2, and it says electricity, and you can see that was whited out. What was there before? What did you white out?
I'm not sure. I made mistakes.
Ma'am, it's your handwriting, correct?
Yes, it is.
And if we look at line item 5, do you see gas and oil $200 a month?
Uh-huh,
You
yes.
don't pay $200 a month for gas and oil, do you?
Yes.
You pay it personally.
I don't pay it personally,
Thank
no,
you.
you're right.
That's something that the company pays for, correct?
Not oil, no.
Okay. How much is your oil expense per month then?
No, I don't know. 25.
Okay, so at least $175 of your, excuse me, I just saw counsel look at her client, nod and shake her head, and do a hand motion at her. She should not be coaching her witness and her client at all. And I saw it because I'm looking at this woman and I have peripheral vision, and I turned and watched Ms. Cohen do that. I'm going to demand respectfully that she not communicate with her client while her client's on the stand.
I'm sorry, Your Honor, I suggested my client just take it easy and stay calm.
Okay, well,
There's no reason why she should have to do that, but certainly it's unethical and it's inappropriate.
all right. No more gestures to your client.
Sorry, Your Honor.
Thank you. So at least 175 of that you've represented to the court you pay, but actually it's paid for you on behalf of the company, correct?
Yes, correct.
Great, thank you. Now, let's look at, for example, line item 17. It
Yes,
says $50, and then I think it says tithe. Is that correct?
that is correct.
And what is in parentheses?
I don't know.
Is it your handwriting?
I can't tell you, I don't know.
Okay. Now, you understand that the items that you put on Exhibit 7, you did so under oath, correct?
Correct.
Okay. And is it your testimony that you tithed $50 a month as of October of 2011?
Yes.
And you've since stopped tithing, correct?
I
Yes
have
or no?
since. Yes. Not in October, though. No.
No, I said you have since stopped tithing, correct?
Since when?
We were talking about October of 2011.
I did not stop in October of 2011.
That wasn't my question. Since October of 2011, you have ceased tithing, correct?
Yes.
And to what church did you tithe?
The Catholic Church.
And are you Catholic?
I'm not Catholic.
Objection, Your Honor, relevance.
It's going to go to her credibility. It's also going to, and Judge, if you'll just indulge me, I'm ready to move on from that particular question, but it has a lot to do with credibility. Now, with regard to line item, brief indulgence. When did you stop tithing?
Approximately February of this year.
And okay, let's move on to page 5 of this exhibit. Are you making a claim to have any community interest or any interest in Lace Bark, which is my client's home prior to marriage?
No.
Objection, Your Honor, we already put the stipulation on the record.
I'm looking at her, what she's saying under oath is her real property, Judge, and she has it on her most recent one, because I'm going to show you that there wasn't an agreement, and we've had to prepare for trial and be here, and I'm going to ask that counsel interpose only a proper evidentiary objection, and we move on from there. Judge, a lot of our fees have resulted in the fact that Ms. Cohen would not reach an agreement or a stipulation, so therefore we have had to incur countless fees and thousands of dollars in fees and lots of hours, and this argument that we stipulated to it a week ago doesn't...
Well, you did stipulate a week ago.
Absolutely, Judge.
Right.
But that was a week ago,
Right.
as opposed to weeks and months ago. And even though the offer's been out there and she's and she never communicated. I don't know when they agreed to it.
Which
She's
one are you
never
referring to? Because
communicated it to me.
unless it's subsequent to 619 where you put the agreement on the record, I don't see how that's.
Then I will elicit the testimony and I will make it very abundantly clear to you in closing argument. Now, are you making any claim, strike that, when did you agree to the distribution of assets and debts that was put on the record last week?
I have no idea what I don't understand what you're saying.
Okay. You understand that last week when we were here before the court, both you and Mr. Feindell listened while we put certain things on the record saying you would be getting certain items, or he'd be getting certain items, or at least at a minimum, we said that the assets and debts had been resolved, right? You recall that?
Yes.
Now, that was the first time I had heard that assets and debts were resolved. My question is, when did you make a decision that the assets and debts issue had been resolved?
I can't tell you that.
Was it before we came into court on last week?
I don't know what we're arguing about in court, so I can't tell you that.
I'm going to ask that you answer my questions, and if you don't understand them, ask me, and I'm happy to ask them again. Do you recall that my office 2 months or so ago sent a proposed decree of divorce to your counsel?
Yes.
And you reviewed it, correct?
Yes.
And in it, we agreed that you would keep assets and debts in your name, and Mr. Feindell would keep assets and debts in his name, correct?
That was in the decree. I wouldn't say we agreed. It wasn't agreed to.
But that was, what do you think that we agreed to last week?
I don't know.
Okay. Do you have any understanding that last week we put on the record you were going to keep assets and debts in your name and he was going to keep assets and debts in his name?
No.
Okay. So what is it that you understand was resolved about property and asset distribution?
I'm not sure that I understand anything was resolved.
Okay. So are you still making a claim to any interest in Mr. Feindell's home?
I never did make a claim.
You're stating that you've never asserted in sworn pleadings that you believed that you had a community interest or an ownership interest in Mr. Feindell's home? Yes or no?
No.
Are you asking
that
that
I'm-
the court award you any money or anything related to Mr. Feindell's home?
Not so much as it stands. No.
I'm sorry?
No.
So you're not asking that you be awarded any of the payments made towards the mortgage on the home?
No, I didn't ask for any of that.
Okay. Really? Okay. Then why would you put as real property on your financial disclosure form as recently as last month his home?
I didn't put it on my financial disclosure form as recently as last month.
I'm going
What
to-
are you
ma'am,
referring to, please?
Ma'am, I'm going to ask you to look at Exhibit 7 first, and go to page 5 and look at
Yes.
line 14 and 15.
Yes.
1082 Lace Bark Court.
Correct.
Whose home is that?
That is Tim's home.
Okay. And
that
you
wasn't last
understand,
month.
ma'am, that you put it on your financial disclosure form as real property, as an asset of yours, correct? Yes or no?
It's on the paper, yes.
Great, thank you. And you wrote it down on the paper, right?
Yes, I
It's
did.
your handwriting, correct?
Yes.
Okay, now I'm going to ask you to look at Exhibit 8, which is your financial disclosure form. That was 52412. Tell me when you're on page 5. Are you there?
Yes.
And on line 15, it has Mr. Feindell's home, correct?
Yes.
And do you understand that by you placing, so first of all, does that refresh your recollection that in fact you did put his home on your financial disclosure form twice, as recently
I
as
didn't
last
say
month?
that I hadn't.
Ma'am, you said you didn't recall. Does that refresh your recollection now?
Yes, it's there.
Great, thank you. Now, do you understand that by placing his home on your financial disclosure forms, it would be a reasonable interpretation that you were making a claim to a portion of that home?
No.
Okay. And what was the purpose of you putting his home on your financial disclosure form if you weren't asking the court to award you a portion of it?
That was the home that we lived in together. I didn't understand that that's the assumption.
Did you review your financial disclosure form with your counsel?
Yes.
Okay. Now, Let's look, please, at your Exhibit 7, please. And I'm going to ask you to turn to page 6 of 7. Tell me when you're there, please.
I'm there.
What do you have listed under retirement accounts on line 39?
I don't. I have NA.
You have NA, and you wrote that in your handwriting, correct?
Yes.
And does NA mean not applicable?
Yes.
Now, let's flip to Exhibit 8, and let's look at your financial disclosure form, and it says 5 and 6 of 7. Tell me when you're there, please.
I'm there.
And you see retirement accounts, line 39? What's listed there, please?
AXA Equitable.
And it's valued at what?
$8,000.
And it wasn't listed on your first one, right?
No, it was not.
Okay. And now all of a sudden you have $8,000 in retirement funds? Is that correct?
On this financial, the newest one, I recalled that I had that, yes.
Great, thank you. Let's look also, please, on Exhibit 8. And let's look at 5, 6, and 7 again. Do you see where it says debt in the middle of the page?
Yes.
And under long-term debt, you have auto loan, correct?
Correct.
And under other debt, you have Wells Fargo Visa, Best Buy credit card, Kohl's credit card, and student loans, correct?
Correct.
And that's the sum total of the debt that you have, correct?
Correct.
Thank you. So when you testified under oath that attorney's fees were paid by loans from the company, Western Sealants, if you in fact had loans to Western Sealants, you would have listed that on your financial disclosure form, correct?
Objection, misstates
Yes.
her testimony.
Sorry, my book fell
Sure.
distracted me. Give me one.
Do you recall,
Question again?
thank you.
Sorry.
If you had loans to Western Sealants, they would have been listed on your financial disclosure form under debt, correct? Okay. So when you testify in your interrogatories that you had loans from Western Sealants, those have either been repaid or that was an untrue statement, correct?
No.
Okay. You understand the disparity in your testimony, do you not?
No.
Objection, argumentative.
Thank you. Now, you have made assertions that Mr. Feindell did not produce any documentation related to job search, correct?
Say that again.
You've made representations as recently as your pretrial memorandum that Mr. Feindell did not provide evidence of any job search, correct?
Correct.
Now, I'm going to ask that you look in the big book, 1 of 2, and I'm going to ask that you go to Exhibit 10. Exhibit 10, Judge, I'm going to ask for its admission. It is Mr. Feindell's responses to the first request for production of documents.
No objection.
While we're looking, I would ask for admission of 1, 2, 3, 4, 5, 6, 7 and 8 were already admitted, 9, 10 was already admitted, 11, 12, 13, 14, 15, 16, 17, and 18.
Your Honor, if I may have a second to look.
I think they're all pleadings, correct?
I don't
Ms.
object to
Luberts?
any pleading being admitted.
Great, so then 1 through 18, as I understand it, will be admitted.
Well,
You could go to 19 and 20 is also production.
Is there any objection to 20 being admitted?
It looks like 21's a production as well.
Right. 20 and 21, are there any objections?
Just a moment.
Thank you.
No objections through 21.
All right.
Water in the corner.
Through 21 will be admitted by.
Thank you, I appreciate that. Now, going back to number 10, remember those bait stamp numbers I told you about?
Yes.
Ours are going to be a little bit different. They're going to start with a TF. So I'm going to ask you to go to TF 0136, and it's under Exhibit 10. It's towards the end. Please tell me when you're there. And I'd like you to take a look at Exhibits TF 0136 through TF 0169, and tell me if you know what those items are.
They are ads for. They're wanted, help wanted ads.
Now, are they ads or are they documentation of ads that Mr. Feindell applied for?
I have no way of answering that.
And have you seen these documents before today?
Yes.
And you still stand by your assertion and your statement that Mr. Feindell has yet to provide any proof of any job search that he's conducted, correct? Yes or no?
He's provided help wanted ads.
Ma'am, answer my question, please.
No. Oh, I'm sorry. Restate the question, please.
Sure. Do you still assert that Mr. Feindell has not submitted any documentation related to job search?
No.
Thank you. Now, do you recall early on in this case, I believe at the first hearing, you asked that Mr. Feindell subject himself to a drug test?
Yes.
And do you recall the court stating that if he came back clean, you would be responsible for repayment of the cost?
No.
Have you repaid, strike that, you're aware that Mr. Feindell was found to be clean of any illicit drugs, correct? Yes?
Yes.
And that any drugs in his system were consistent with, any prescribed drugs that were in his system were consistent with prescriptions he had and were also approved by the court. Do you recall that?
Yes.
And do you recall that prior to having, strike that, and so have you made any offer to Mr. Feindell to repay him for that drug test as was ordered by the court?
No.
Okay. Now you look puzzled. Is that puzzled look because you don't recall the judge making that order?
I don't recall the judge making that order.
And if the judge did make that order, how quickly will you pay Mr. Feindell?
As quickly as necessary?
I'm sorry?
As quickly as the court orders?
Okay. So then you don't have any objection, obviously, if that was something ordered by the court, correct?
No, I will follow the court orders.
Okay, I appreciate that. Let's move back to Exhibit 19, please. I'm going to ask that you follow along with me. On page 2, it's the first one of the second book. Tell me when you're there, please.
I'm there.
You've seen this document before, correct? It's your response to the first request for production of documents?
Yes.
Now, the first request asks for financial statements that have been prepared on your behalf or on any entity in which you have an ownership interest as of the date of marriage to the date of production. Do you see that?
Yes.
And did you produce any such documents?
No.
Why is that?
Because we objected to it.
Okay, and what was the basis for your objection?
Do you want me to read it here?
Well, no, you said you objected. What was objectionable about it?
Objection calls for a legal
Abstain.
conclusion.
She's the one who said we objected to it, but that's fine.
It's right
Now,
here.
Listen,
the evidentiary
it's
objection?
sustained.
Thank you.
First of all, and if you had any discovery problems or was non-compliance, we should have done this with the Discovery
But
Commissioner.
I don't need to. I'm going with credibility, and it has to do to child support and fees. So again, if I
That's really reaching at this point.
Sorry?
That's really reaching at this point.
respectfully, I disagree, and I'd ask that you not make any opinion until you've heard all the testimony and the
If
evidence.
you had any problems with discovery, then you could make
That's fine.
you get the frivolous type of responses through the Discovery Commissioner. I don't award those
Absolutely,
type
but
of
you
fees.
also can take an adverse presumption when there's been spoliation of evidence and non-production of evidence.
Disagree.
Under the-
I defer to the Discovery Commissioner. If you believe there's frivolous or non-compliance with discovery, fees at that point come through the Discovery Commissioner, not
There
me.
is a specific Nevada revised statute or NRCP that says that the court, not the Discovery Commissioner, the court can take an adverse presumption when there is spoliation and non-production of evidence. And that is something for the court to determine. It's an issue of law and not something for the...
Would that be a can or a must?
I'll have to go back and pull the statute. I believe, I don't know, and I don't want to misstate it.
I've always been clear. I defer to the Discovery Commissioner. If you have problems with discovery, non-compliance, anything else, that
I'm not
those attorneys.
talking about non-compliance. I'm not talking about non-compliance. I just haven't been able to finish my question because I got interrupted on an objection that I don't think had any basis, but you sustained it, so I'm ready to move on. Great. Now, you state on page 2, line 4, moreover, defendant does not have access to and control over these documents. Do you see that?
Yes.
Okay. And you are the managing member of Western Sealants, correct?
Objection. Ms. State's testimony, she never said she's the managing member of Western Sealants.
I'm sorry, can I ask that we not have speaking objections so she's not coaching her client? An objection is you state the objection and you don't state anything further. I get in trouble all the time for doing it because I'm terrible about it.
Ask her why she's objecting, and she's just simply clarifying. Do we do that
She
all?
made her objection, but now she's testifying. It's called a speaking objection.
Understand the objection?
Do I understand it? Oh, sure, and I know her client understands it and what she's supposed to state now, too. That's why we don't do speaking objections.
No, and Your Honor,
So my question, ma'am, is, it states, moreover, defendant does not have access to and control over these documents, correct?
Correct.
You are a managing member of Western Sealants, correct? And as a managing member, you do have access to financial statements for Western Sealants, correct?
I do not.
And you're also the office manager, correct?
Correct.
And as the office manager and owner, you would have access, correct?
I do not.
Did you? Who would have access?
The president. The
Who's the
51%.
I'm sorry?
Pat Larson.
And Pat Larson is listed as the president where? With
In
the
the
Secretary of
LLC.
State's office.
In the LLC.
Okay. Have you looked at the Secretary of State website with regard to Western Sealants anytime recently?
No.
And can you tell me when, and remember you're under oath, can you please tell me when Pat Larson was last listed as the president, according to the Secretary of State's office, over Western Sealants?
I have no idea.
Now, Pat Larson is your mother, correct?
Correct.
Did you ask Pat Larson for a copy of any financial statements for Western Sealants?
No.
So you don't know whether or not she'd have given them to you if you didn't even ask for them, right? Yes or no?
No.
Okay. So you don't know if you had access to them. Oh, strike that. So you could have had access to them, correct?
Could have.
Absolutely. Now, can I refresh your recollection? Strike that. Do you need your recollection refreshed as to who is listed in what capacity for Western Sealants with the Secretary of State's office?
Yes.
May I approach, Your Honor?
She doesn't have it?
No, it's just refreshing her recollection. Have you seen a document like this before?
Yes.
And what do you understand that to be?
The LLC documents.
From the Secretary of State's office, correct?
Yes.
And do you see here it was printed out on 6/26/12?
I see that.
And what's today?
Today is 6/26.
Great. And Pat Larson is listed as what, please?
Managing member.
And you're listed as what, please?
A managing member.
And your brother's listed as what?
Tyler is listed as a managing member.
How about Daddy?
My father is listed as a managing
Great.
member.
Now your father is, I'm sorry, is this your brother seated here today?
Yes.
And your brother is a managing member as well, correct?
Yes.
Did you ask him for those documents?
No, I didn't.
Okay. How about Dad?
No, I did not.
Okay. And you understand, again, that in order for the court needs to have, with regard to attorney's fees and child support, this court needs to have a good understanding of what assets and what your financial circumstances are, correct?
Objection asked and answered repeatedly.
Sustained.
Thank you. So we'll just understand that she said, yes, the court should have that information, because that's how she's testified. I
Objection.
don't have to keep
Sustained.
asking it.
Sustained.
Now, I'm going to ask you to look a little bit lower in number 3. Strike that, number 2. I asked for a copy of all loan applications which defendant or an entity may have an ownership interest, etc. And the only thing that you mentioned was you applied for a personal loan with Utah Power and Light Credit Union, correct?
Correct.
And you said you did that to pay for the custodial evaluation and attorney's fees online, and that you were denied, right?
Correct.
Do you have an account at Utah Power and Light Credit Union?
I don't.
Have you ever?
Yes.
When was the last time you had that account?
I couldn't say for sure. It's been quite a while.
Before or after the marriage?
Before.
And does Western Sealants have any accounts with Utah Power and Light Credit Union?
No.
Did you make any application for loans to any other banks with whom you do have a banking relationship currently?
No.
Now, you had, at the same time that you were making application for that, you had $2,500 or so available on credit cards that you possessed at that time, correct?
Yes. Well, I don't know if that's correct, actually.
Okay, we'll go through and I'll show you those documents in a little while. Does Western Sealants own any real property?
No.
Does it own where its office is located?
In the residence of my parents?
And how is that residence titled?
I don't know.
So you don't know if it's titled to Western Sealants?
It is not titled to Western Sealants.
Are there any other business entities, LLCs, corporations in which you have an ownership interest?
No.
Do you own any real property?
No.
Brief indulgence, Judge. I'm trying to wrap up as quickly as I can. I'm going to ask you to take a look at, in Book 2 of 2, number 19 still. And I'm going to ask you to go to I'm sorry, it's not number 19 because it's one document. It is. Number 19, and it's date stamp AF187. Please tell me when you're there.
Yes, there.
If you would look at 187 through 193, and tell me what those are.
these are this is a credit card statement.
Can you tell me where your name is present anywhere on those pages? Or anything that would evidence that they belong to you? If you'd agree with me, there's no names and there's no addresses and there's no anything that identifies. They're just some pages that are incomplete. Correct?
Your Honor, I'm going to object to relevance. Division of assets and debts is done.
Because she is. Do you want me to respond and give an offer of proof?
You need to tell me why it's relevant. Yeah.
It's completely relevant because it has to do with the fact that she has been hiding information, and it all has to do to her, as to her wealth, and which will impact child support and attorney's fees. For example, if we move to the next set of just so the court understands, the next set of credit card statements starting at 194, ending at 225. 194 to 206 include pages 1 and 2, which shows credit card statements with her name on them, and it also shows how they're being paid, which is through Wells Fargo Bank. And suddenly and mysteriously, as we get close to the parties having a lot of difficulties, there is nothing there is only one page of each of these statements, and they don't show, and I misstated the number where it stops, it's actually 210, where now all of a sudden, mysteriously, we only get one page, and the banking information is not there. And we have her applying not to Wells Fargo for a loan, but to a place in Utah where they're from, where Western Sealants was originally based out of and originally created. And I believe that she is hiding assets, and I'm evidencing my good faith belief for that.
I think
Ma'am, can you tell me? I'll withdraw that question. Can you tell me why you in the statements July of 2010 in your production only included page 1 of each statement?
It was an oversight, merely an oversight.
Okay, so it was an oversight. Hold on. It wasn't an oversight from November 20th, 2009 until November of, until July of 2010. So for almost a year it wasn't an oversight, and we saw that it was Wells Fargo Bank. But from October of 2010 until the last one, which was October of 2011, that was the oversight?
Apparently, yes.
Thank you. Do you have any bank accounts other than the one Wells Fargo bank account that you have disclosed?
I do now, actually, through Wells Fargo. I have one more checking account.
When did you open that account?
When I moved into my apartment.
Which was when?
June.
Is it listed on your financial disclosure
You know what,
form?
actually, I misstated that. It wasn't in June. It was quite a bit after that. I can't tell you for sure.
Was it in 2011?
No.
Was it in 2012?
I opened it so I could pay rent out of that checking account.
Okay, and when did you move into the apartment?
June of 2011.
And how are you making the payments?
Out of my regular
Excuse me,
checking
ma'am.
account.
How are you making the payments in June of 2011?
Out of my checking account, my regular one.
And why did you find the need to open another account simply to pay your rent?
Because it helps me to track my finances better.
Okay, and what else do you pay out of that new account? And did you have that new account before May 24th of 2012?
Yes.
Why isn't it on your financial
I
disclosure
forgot
form?
to put it on there, and I'm disclosing it now.
Great, thank you. But you understand you're disclosing it at the time of trial when I can't do anything to get any documentation on it to find out how much money you've got in it, right?
I can tell you how much money is on it.
You know what, ma'am? Let's not go there. Please answer my question. And my question was, you're disclosing it for the first time at the time of trial, correct?
Correct.
And at the time of trial, unless the court's going to reopen discovery, and allow me to get that documentation, I had no way to know about that or that account or to verify that account, correct?
Correct.
And you just forgot about it?
I actually did not even think about it.
Thank you. You understand how that could cause Mr. Feindell some mistrust of you about disclosing all assets?
I just disclosed it.
Yeah. Do you understand how disclosing it right now could cause some mistrust of the veracity of your statements?
No.
Okay. And you also just forgot your retirement account?
Yes, it was an oversight.
Thank you. And you just forgot the pages that would show us out of what bank you were making
I already
payments.
said that. It wasn't a forget.
Hold
No.
on, you really are talking over to her. You
I'm
need
sorry.
to wait till she stops talking before you answer a question.
Noted. Sorry.
I got the answer. Does the judge need to hear it again?
I don't.
What else have you forgotten, and what else is an oversight that should be on your financial disclosure forms?
Nothing that I can think of.
Okay, but we don't know if you'll think of it tomorrow or later on, right?
No, we don't know.
Okay, thank you. Now, when you signed the lease, or I'm strike that, when you moved prior to moving in, I'm sorry, it's been a long week already, did you have to fill out a credit application to move into the Equestrian?
No, I don't believe I did. I can't recall.
Okay.
I had to fill out an application. I'm not sure if it was a credit application.
Okay, so you had to fill out an application, correct?
Yes.
And you understand that generally apartment or people who lease apartments like to make sure that you're not someone who has a history of skipping out on apartment rentals, right?
Right.
And so you understand that it's probable that they ran a credit check on you, correct?
Correct.
Okay. Now, I asked for any applications for credit and loan that you had received, that you had initiated, and you didn't include a copy of that application in your responses to my request for production of documents, correct?
The equestrian documentation is included in.
Just the lease itself, your application that has your financial information on it, that wasn't included, right?
No, I don't believe so.
Okay. And you understand that an application such as that would have requested banking information and credit card information, right?
I don't know if it did or not.
Okay, thank you. Let's talk about child support. Mr. Feindell was unemployed at the time of marriage, correct?
Correct.
And he was unemployed at the time that you and he decided to, well, let me ask you this. Was Ivy planned or unplanned?
Ivy was planned.
And he was unemployed at the time that you and he planned to conceive a child, correct? And he was employed, except for a few odd jobs, he was unemployed during the entirety of your marriage, correct?
Correct.
Now, did you ever file joint tax returns in any year with Mr. Feindell?
Yes.
And what year was that?
Well, it would have been 2009 and 2010.
And what was his sum total of income for 2009 and 2010,
I
if you
can't
recall?
recall.
Is it fair to say it was less than $10,000 both years?
Fair to say, yes.
Now, at the time that you and Mr. Feindell married, do you believe that he was unemployed for the purpose of avoiding child support?
No.
Okay. And at the time that you guys conceived Ivy, or agreed to conceive Ivy, or tried to conceive Ivy, do you think he was unemployed for the purpose of avoiding child support?
No.
And when is it that you believe that he suddenly became unemployed for the purpose of avoiding child support?
I don't know that I can answer that.
Because he was unemployed throughout the whole marriage, right?
That is correct.
And do you understand that in order to find willful underemployment, that it has to be for the express purpose of trying to avoid child support?
Objection calls for a legal conclusion.
Just asking if she has an understanding.
And it calls for a legal conclusion. I'm not going to have that come from a witness.
Do you recall back in, I want to say May of 2011, Mr. Varicchio was your counsel?
Yes.
And do you recall the four of us, meaning Mr. Varicchio, you, Mr. Feindell, and myself, meeting in Mr. Varicchio's office?
Your Honor, I'm going to object to this line of questioning because it sounds like we're getting into
She hasn't asked it yet.
negotiations.
She hasn't asked it yet. When she does, you can make the objection.
Go ahead, please.
We were in the same office. We didn't meet together.
Okay. We were all in the same office, meaning Mr. Varicchio's office, for the purpose of attempting to resolve the issues in this case, correct?
Correct.
And that was more than a year ago, correct?
Correct.
And that was tens of thousands of attorney's fees ago, correct?
Correct.
Okay. And do you recall reaching an agreement whereby you and Mr. temporary or otherwise, that you and Mr. Feindell would have joint physical custody and joint legal custody?
Objection, and
No.
now we're getting into negotiations.
We're not. I'm asking if she recalls that agreement.
No, I don't.
Okay. Now,
The custody thing I'll allow.
excuse me, Judge?
I will allow the agreement for temporary, if they reached an agreement for temporary custody. That's
Great, thank you. Now, you indicate that no agreement was reached, right?
I don't indicate that no agreement was reached. It was not my understanding that it was temporary joint custody.
Okay. You had counsel there at the time, right?
Yes.
And the timeshare that was agreed to temporarily was at least a 60-40 split of time between you and Mr. Feindell, correct?
I don't know.
Do
Well,
you recall that it included at least 3 overnights for him? Because you only wanted him to have 2 overnights, and we had agreed to be 3 overnights?
I don't recall that.
Okay. Is there anything that would refresh your recollection?
Is there paperwork?
I'm sorry?
Is there paperwork?
Well, I'm just asking right now if there's anything that would refresh your recollection.
Paperwork.
Okay. Any paperwork in particular?
I don't know. I don't recall having paperwork from that meeting.
Okay. I'm going to ask that you would please turn to Exhibit 4. Tell me when you're there. I'm going to ask you to go to page 3. Tell me when you're there, please.
I'm there.
And I'm going to ask you to follow along starting at line 23. And please remember, this has already been admitted into evidence. A copy of the email from Amanda's mother is attached here too as Exhibit 2 and is incorporated herein by this reference. The court should note the following, and please tell me if I misread anything. Mandy agreed to allow Tim to have 3 overnights a week for the next month. Dean and I completely disagree with this. Let's go to the next page. My suggestion to you is you tell Tim to back off and take what he has been offered. Tim has a lot more to lose than just Ivy. We're very willing to speak with Jackie. Who's Jackie?
Emily's mother.
And will support her in any way, in any and all litigation that may come from this, as we feel that Emily is also at stake. I'm also sure that social services will be interested to know that Tim has a minor child in his home with no income. There are also tax issues. Have I read that right so far?
Yes.
Please don't make me resort to being nasty. Mandy has been nothing but generous with Tim, and he keeps wanting more. He wanted joint physical custody, right? And that's what this refers to,
I
correct?
don't know that that's what this
Thank you.
refers to. These are
Now,
not my words.
That's fine. Now let's move down a little bit more. I would expect Tim to notify Mandy that he will accept Tuesday and Thursday overnight. We have told the lawyer to spare no expense, and if it comes to revoke all of Tim's parental rights, is that what you want? Did I read that correctly?
Yes.
Now, that was an email written by your mother, correct?
Correct.
And the email in its entirety is attached as Exhibit 2, correct?
Correct.
And it was sent, if you look at Exhibit 2 of the same document, the date's 5/27/11 that this was written. Do you see that?
You said Exhibit 2. I don't see that.
Exhibit 2, I'm sorry, ma'am, it's Exhibit 2 to this exhibit. If you'll just keep flipping the pages from where you were.
I don't know where we were.
Okay, I'm sorry. We were on, I believe, number 4. And I'm asking, I know it gets confusing when we have exhibits to exhibits, so I apologize. This is Exhibit 2
Yes.
to Exhibit 4.
Okay.
And Exhibit 4 is Tim's reply to your opposition, correct?
Yes.
And I'm going to ask you, ma'am, what date was that email written?
The email was written on 5/27/11.
Great. And what date did we all meet? And strike that. What time was that written?
7:49 p.m.
And that was the same day that we all met in Mr. Varicchio's office, correct?
I don't know that for sure.
Okay. And you do know at least that we were not there until 7:30 p.m., correct?
Oh, yes, correct.
Okay. And you do see where Mom wrote on the email that Mandy agreed to allow Tim to have 3 overnights a week for the next month, right?
Correct.
And that was the temporary agreement that was reached, correct? Yes or no?
That was no.
Okay.
I mean, well, yeah,
How
wait
did
a minute,
your
wait a
mom learn-
minute.
But no, ma'am, you don't get to do that. Okay, you said no. I'm going to ask you another question.
Okay.
How is it that the same day that the 4 of us met, your mother authored an email knowing that Tim had been allowed 3 overnights a week for the next month, if you didn't tell her?
Objection. She has no idea what her mother knew.
But
Judge, please. It doesn't call for speculation. How is it if you didn't tell
hold
her?
on.
How is it that your mother knew?
Ms. Lubert, ask the question again. Originally, I thought that it didn't, but go ahead and ask the question again.
Sure. Do you have an understanding as to how your mother knew that Mr. Feindell was offered or was given 3 overnights a week for 30 days, the exact same day that the 4 of us met with Mr. Varicchio? Do you have an understanding as to how she was aware of
Yes.
that?
That was an agreement. Yes.
Thanks. Thank you. Appreciate it. And that was an agreement that you participated in, right?
Yes.
Thank you. And after that, you came in and asked this court for primary physical custody, correct?
Correct.
And there'd been nothing that had changed since May 27th of 2011, and when you filed your opposition asking for primary physical custody, there'd been nothing that had changed about Mr. Feindell, where he was no longer a suitable joint physical custodian, correct?
Nothing had changed.
There was nothing about Mr. Feindell that made him unfit between May 27, 2011, when you agreed to joint legal and joint physical custody, and when you filed your opposition a month later, correct?
Objection.
Yes or
There
no?
wasn't an agreement to joint legal and joint physical. There was an agreement to temporary. There's a big difference.
Okay, I'm
It's
sorry.
just confusing the witness.
I'm sorry. Let me rephrase the question then. Nothing changed about Mr. Feindell from when you agreed to temporary joint legal and physical custody of Ivy May 27th of 2011 and when you filed your opposition about a month later, right?
No.
Okay. Now, you'd agree that it took tens of thousands of dollars in attorney's fees to get from temporary joint legal and physical custody May 27th of 2011 until when you signed your parenting plan for joint legal and joint physical
Yes.
custody, right? Yes?
Yes.
You say tens of thousands or 10,000?
Tens of thousands.
Would be a little more specific.
Sure.
My own edification.
You've incurred attorney's fees between May 27th of 2011 and the date that the parenting plan was filed.
I incurred attorney's fees, yes.
How much?
I couldn't say for sure without looking at the numbers, but it wouldn't have been over 10,000, no.
Okay, but let's say it was 10,000. Is that about the right?
No, I don't know. I don't know.
Okay, because as of October of 2011, you had paid Mr. Verricchio $3,500 and owed him another $6,000, and you had paid at that time Pecos Law Group almost $10,000, and that was October of 2011, according to your interrogatories.
Yeah, maybe that is correct.
Okay. And you understand that Mr. Feindell has incurred similar fees, correct?
I don't understand that. No, he didn't state that in his paperwork.
Thank you. So that's where I get tens of thousands, because if you spent over 10 and he spent over 10, that's tens of thousands, right?
Okay, yes.
Yes? Okay. Now, and we wound up in the exact same place, right? With joint legal and joint physical custody.
No, because that wasn't the original understanding as I understood it.
All right. Now, during that time period, you also demanded a custodial evaluation, correct?
I did.
And in that custodial evaluation, Dr. Mortalero indicated that there was nothing that precluded Mr. Feindell from being a joint legal and joint physical custodian, correct?
Correct.
And that he found him to be fit, correct, to do that, yes?
Correct.
Okay, and even after that point, you would not agree to joint legal and joint physical custody, correct?
No, that is not correct.
Okay, you didn't agree to joint legal and joint physical custody until you went to mediation, correct?
Correct.
And how long after Dr. Mortalero's report did it take until you engaged in that mediation and agreed to joint legal and joint physical custody?
I don't know.
Okay.
I don't
Now,
know.
as recently as last month, you were trying to change the custodial timeshare, correct?
Correct.
And you so when is it that you decided not to excuse me, as of last month, Mr. Feindell had reason to believe that custody and visitation had not been finally and fully resolved, correct?
No, that's not correct.
Because you were seeking to modify it as of last month, weren't you? Yes or no?
Yes.
Thank you. And you understand that because of that, a reasonable inference may be drawn by Mr. Feindell that you were not satisfied with the custodial timeshare, correct? Because you were seeking to modify it.
What
Yes
do
or
you mean
no?
by custodial
State's
timeshare?
You
testimony.
don't understand custodial timeshare?
Well,
So, let's hold on. Are you going to re-ask the question?
Yeah,
She's
I'll be
objecting.
happy to.
All right.
Do you understand what custodial timeshare means?
as you're referring to it, I'm not sure how you're referring to it.
As recently as last month, you wanted to change the time that Tim had with your daughter,
I
correct?
wanted to change the
And
visit.
yes or no?
Yes.
Okay. And when I refer to custodial timeshare, understand that's what I'm referring to, his time and your time, okay?
Okay. Yes.
Now, if as recently as last month, you told Mr. Feindell that you wanted to change the custodial timeshare, then he could reasonably draw an inference that you were not satisfied with the existing timeshare, correct?
Correct.
And therefore, it is a reasonable inference that he would have discussed it with his counsel and spent attorney's fees on that issue, correct?
Sure.
That's
Correct.
a reasonable inference, is it not?
Sure.
Great.
Correct.
Can I just ask my own asking, who paid for Dr. Mortalero?
Mom did. And she's still in the process of paying for it. And actually, the community did, because everything that they have is community property, and so the community has made those payments. However, tens of thousands of dollars in fees were incurred, and that is one of the bases for our request for fees. Now, brief indulgence, please. Judge, may we take a 5-minute break so I can see if I can wrap up?
Yeah, actually, let's go 10. We'll be back at
Got it.
5 after. And then we'll start by kind of guessing at our time, because if, in fact, we're not done by 5, we'll have to pick another day that we can all come back. So.
I can't imagine that I won't be finished by 5.
All right. All right, we'll be in recess till 5 after.